Welcome back to another edition of the Dirty Verdict podcast. I'm one of your hosts, full-time mediator in Houston, Texas, Peter Taaffe.
I'm Kyle Herbert, your second host. Maybe number one in your hearts, number two in your program.
Yes, and we are missing our dear friend Bill Ogden, whose grandfather passed away, and so we send our thoughts and prayers to Bill and his family on loss of Bill's grandfather. So we're missing Bill today, but we are joined by a great guest, Matt Mussalli. Thanks for joining us, Matt.
Great to be here. Thank you.
But anyhow, but this came about because our friends at the Zell law firm, past guests, notably Mike Strike, I think is the one who emailed me and said, have you go check out this trial going on in I think it's the 165th. And I watched a little bit. And then after it was over, he's like, we listened to the whole thing. This was absolutely fascinating. It was like a TV show or a movie. You got to get Matt on it. Then he copied Matt and I on a email. And so we've been working on this was last year was when the trial happened. So we've been working on getting this set up for a while. So, well, let's get into this fascinating case.
Yeah, this is crazy.
So the case, I'll set a brief stage. I want to steal Matt's thunder. So it is homeowners, a couple that hired Matt's client, Kevin Spearman Design, to do some design work for the house, and maybe was it construction too? Some renovations or just the design?
Just design.
Okay, just design. And things went south, and there were some disagreements that ended with a jury trial in 2024 in the 165th, which at the time was Ursula Hall. The ask for various damages, which were there some like emotional, mental anguish claims that were submitted?
There was a claim made, but not submitted.
Okay.
Just before the charge, they non-suited their mental anguish claim.
Okay. But they talked about it at length, at least according to what I
They
heard.
did.
Okay.
And they did during the trial.
So the ask of the jury of Matt's client was the damage award was requested at 5.598 against Kevin Spearman Design and 3.86 against Kevin Spearman individually. And I'm talking $1 million. The net outcome of the jury verdict was kind of a very small, and Matt can walk us through the legal, but the net takeaway was it was what we call a take nothing judgment, meaning defendant wins. Is that right?
Yes.
Okay. All right. So Kyle, are you doing renovations on your house right now?
I live in an almost 100-year-old house, not far from where these plaintiffs live, right by Rice University. And I wouldn't say that propping that pile of bricks up so it doesn't descend into the bayou is considered design. But to the extent it's not currently collapsing in on itself, it looks, like kind of a 100-year-old shack.
Okay.
Thanks for asking, Pete.
Yeah. Well, we won't, we'll hire Kevin Spearman.
If I could possibly afford it, I really would.
So and we don't need to name the plaintiffs, although it's public record, or the lawyer, unless you want to. Just suffice to say they're a well-to-do, I think older than us, I guess. So that's, yeah.
I'd say they were late 60s, early 70s.
Okay.
And second marriage, I believe, for each of them. So kind of a new start, a new home. The comment about the project went south. Actually, the project we don't think went south.
Okay. In their mind, at least.
Yeah. I mean, it's a big distinction because much like you see on TV when there are these design shows and there's a big reveal and there's this aha moment, and maybe it's a watershed moment for the customers. In this instance, these homeowners liked the project. They thanked Kevin for a great job. Kevin and his team felt like they had gone above and beyond the call of duty. They were pleased. They are certainly customer service driven and wanted to do a good project. And so they didn't think the project went south. There were some questions about specific pieces of art. Does this really work here? And can we have it for a little while? And one of the features that his company, Kevin's, offers is when they bring arts or accessories into your home, it's your choice to either buy them or request that they be taken back at no charge. But once you live with the artwork or the accessories or whatever it may be for some period of time, by then you will have had a fair opportunity to decide, does this work for us? Does this work for our home? And not a single item was returned.
And that's specified in the contract that
there is the arts and accessories part is specified in a different way. It's also priced differently. But certainly what Kevin shared with these customers is that they could have a period of time, and I don't think he was holding a stopwatch to them on the number of days. I think he wanted them to feel comfortable and really like the pieces that he had and his team had placed for them.
How much was the initial contract? Like, what was the scope? How much were they trying to spend on this house?
So, if you ask the plaintiff in deposition, which I did, he had no budget, but he clearly had a budget. The spend was $374,000. And so there were certain pieces of furniture that I think designers I've learned might call them bones, for example, bigger pieces, large tables, beds, things like that these homeowners wanted to keep. And then there were other things that they were open to replacing. But the new furniture included lamps, some tables, window treatments, a number of enhancements to the house. And, by most accounts, I think even the plaintiffs, it was a beautiful project. And we had before pictures and after photos, compared them, showed them to the jury. I think it was a very striking difference. And so I think the real issue came with this desire to have a piece of paper, a receipt reflecting the manufacturer's name, the date, the price that Kevin Spearman paid for it, the price that the Darrows paid for it, and having that for every single item. And I know you're familiar with Kevin's old building.
Yeah.
It's a very large warehouse. And as a company who had been in business for several years, they would go on buying trips and buy in bulk and basically develop a very curated collection, curated to their taste and what they felt customers in the Houston area and really around the world would like, because Kevin has done projects internationally as well. And so when that happens and you collect from all different parts of the world, the ability to produce a piece of paper with a birth certificate, call it, for that item becomes more difficult. And so when these plaintiffs ask questions about, again, documentation and wanting more and more and more, and they weren't pleased with the results, I think that's when the relationship became very strained. And so they hired counsel.
So hold on. They enter into negotiations. They sign a contract. Project's done. I'm supposing some amount of time goes by, and they say, well, we want to down to the dollar accounting, and if you can't provide that, we're going to...
Well, I even need to back up from that. Are these the items that it was agreed to? They weren't buying. They were just being placed there to decide whether they wanted to keep them or not?
Some of them were those items, but you hit the nail on the head. I mean, pretty much everything you said I would agree with except one piece.
Yeah.
And that is the contract was never signed.
Interesting.
It is the most interesting feature of the case, in my opinion, because we presented them with a paper contract at their home. They both acknowledged receiving it. Spearman Design Group's protocol is you present the contract, ask the client to sign it, receive it, place it in a physical file folder, and it stays there. If there's a need to take it out at another time, it comes out. Otherwise, that folder will stay closed for the life of the project. This project began in February of 2000 when
2020?
2020. So the project began in February 2020, at which time COVID was just starting to hit, right? And so the ability to interact and meet in person and exchange information and do all the things that one might do normally was inhibited for sure. And Kevin Spearman and his team, were unable to find a signed copy of the contract. They believed that these homeowners had signed the contract. And they believed that because they paid in accordance with the terms of the contract. They made an initial payment of a design fee. They paid a deposit. Everything they did was lock and step, just what the contract called for. And in turn, all of my clients' performance was exactly what the contract called for. So this whole time, my client is thinking, we've got a signed deal. Had no need to go back and open the contract. Yet on the flip side, it appears the homeowners were thinking they made an oral agreement. When this lawsuit got filed in September of 2021, I was looking for a cause of action for breach of contract, right? Because even your questions are, well, wait a minute, isn't this what they agreed to? And I flipped through. I saw negligence. I saw negligent misrep. They did not make a claim for breach of contract. But it says that they engaged Spearman Design Group. So how does one engage someone to do work without a contract? And if you're going to say, well, it was an oral agreement, fine, it's still a contract.
Plead it, yeah.
No such pleading. In fact, breach of contract didn't get added until a year before trial. So that would have been 2023. So this case, we did discovery on it, including depositions, when there was no breach of contract claim even pled.
Were there like money hadn't received or quantum merit or any of the equitable?
No. The plaintiffs alleged fraud, Deceptive Trade Practice Act violation, and they wanted a declaratory judgment action. But I think they snapped to it, and they did sue for breach of oral agreement, again, much later in the game. The items that were at issue, it did include some arts and accessories which were offered for a fixed price, kind of like take it or leave it. This is what we think is a price that we're willing to sell for. If you love it, great. If you don't, no harm, no foul. We'll take it back. There were other items, again, spelled out in the contract, that would be custom ordered for the homeowners. And there was a 40% margin on those items. And in the contract, it said 40% margin divide by 0.60, not 40% mark up. Okay. So what the plaintiffs attempted to do in the case is first disavow the paper. They said, this is not our contract. In fact, I think the quote was, you might as well be showing me something from Timbuktu. That's not our contract. The jury disagreed. The jury found not only was that the contract, you all but signed it, that was your deal. And so when there were questions about whether my client performed in accordance with the contract, I took the contract, I blew it up. You know, I'm kind of old school. I like those big boards. Sometimes the digital stuff is good, but I like the paper. And
you can't wave around a digital image. If you want to hold it over your head and yell at a jury, you need to have it blown up.
Exactly. And I took that black magic marker and we kind of just checked off each bullet point. Did we do this? Did we perform? And even the plaintiffs had to agree, yes, you did this, and yes, you did that. So the finding by the jury that indeed there was a contract was significant factually, because it showed that they did not believe the plaintiff's version, and that is that they had never entered into a written agreement. And again, the paper was meaningless. And second, it had legal significance, because ultimately the very small amount of tort damages that the jury found was set aside in the take-nothing judgment because of the existence of a contract and the inability to have tort damages when there was a contract in place.
Let me ask, in talking about this beforehand, we talked a little bit, or you showed us some documents where we were looking at the damages claimed by the plaintiffs. And, you start off with $374,000. What were they asking the jury for, and how did they get there, and how did that play?
So they asked the jury, as Peter said, for in excess of $9.4 million.
How much is the house worth?
Probably around, probably about 1.5.
Yeah, I was going to say, I just bought a house over there. I don't think it's worth $9 million.
Yeah, and I'm just looking like out-of-pocket expense. Out-of-pocket is $700,000, and then future out-of-pocket $1 million, and then $561,000. Like, there's all kinds of numbers here.
I think that the adage of be careful what you ask for is true in life, is true in trial. And I think that in this instance, asking for $9 million, in excess of $9 million, probably helped my client.
What was the rational connection between $375,000 and $9 million?
So part of it was they believed punitive damages should apply, and they flat out asked the jury to award $1 million in punitive damages to each of the plaintiffs against each of the defendants. And so they sued Kevin personally, even though this deal was with his company, and they sued the company. And so you've got millions of dollars and several hundreds of thousands in just punishment or additional damages, or what the statute recognizes to be knowing damages for a Deceptive Trade Practice Act violation, all of which the jury found there was no knowing violation. There was no clear and convincing evidence of fraud. There was no fraud. And so how did they rationalize it? I think they said, well, this design fee you charged us, you didn't really do much work for us. We want that back. This methodology for calculating our custom goods, the 40% margin, we think that should have been a 40% markup. And so now we've done a calculation of every single item, and we're going to claim the delta, or what should have been a 40% markup, and you're not entitled to the actual margin. Those are small numbers, right? They pale in comparison to asking the jury to award $561,000 for attorney's fees just through the beginning of trial, and in excess of $1 million through the appellate process. The jury awarded $5,000. They heard direct exam from a very established, experienced, seasoned lawyer at a large firm. Listened to all of that. And when the opportunity arose for me to cross-examine counsel, even though
did they designate an independent expert, or did they use themselves?
They used themselves. But we have the chance as counsel to cross on everything, including fees. And I don't usually like crossing lawyers, but I stood up ready to cross. And for the first time in my career, with a witness who really had something significant to say, I said, no questions.
Yeah.
Small. I haven't done that since mock trial.
All right. I kind of want to peel back a little bit.
Yeah.
Okay. So you got to be thinking when you have a dispute like this. First of all, did you mediate it at some point?
We did.
Okay. So when you mediate.
Did you mediate with Peter Taaffe?
No.
Big mistake.
I probably wasn't doing it yet.
He wasn't a mediator yet. That's right.
So, but I'm always on a case like this, I'm trying to think, okay, what happened? Like, what's the core issue? Because clearly it's not money. I mean, now it's money because people have spent so much money on attorney's fees, but something went crossway where the trust was broken, and that led to some form of anger from the plaintiff that led them to want to hire a lawyer and go get this guy and spend whatever it takes. And so it was very emotional. And I'm just curious if you were able to identify like what happened, just that where the trust was broken to where I'm guessing at that point, no matter anything Kevin said or did, they didn't believe it. They thought he was screwing them around. Like, was there a moment in time?
There was. I learned of an attempt to do a project recap at the end of the project. There was a meeting at Kevin's office. I think he made binders available to the homeowners to review, to their heart's content. I think they found some things. Again, when I say found things, I mean they were able to cross-reference specific items and dollar prices. And I think that where there were no questions, they had to be comforted by that. But there were questions about other things. And it was a small office, or they were in small confines. And I believe Kevin found a Post-it on the floor that was written in one of the homeowners' handwriting that says, they're shafting us on arts and accessories. So that wasn't discovered until after the homeowners left. So Kevin looked at it and was like, what is this? Offended.
Sure.
And went back down after the homeowners and said, I think you left something up here. Here's your note. And I think there were words. So yes, there were certainly emotions, but to be accused of wrongdoing like that, I think hit Kevin in a very personal way. These are folks that he worked hard for and grew to know and trust. And I think he felt very betrayed. And probably on their end, whatever methodology they were using, they got something in their mind that they were somehow not being treated fairly. And I guess they got upset. But there were plenty of chances, Peter, after that, including during the depositions, during mediation, to just basically clear the air, get rid of the emotion, make a business decision before allowing emotion to take over. And this lawsuit turned into, something I never imagined it would be. This was supposed to be a 3-day trial. We're talking about 3 days times 12 jurors, judge, 165th, judicial staff, counsel for plaintiffs, counsel for defendants. Even a 3-day trial is a big deal. It turned into 12 days.
How's that possible? First of all, most judges, if I say I'm going to use 3 days, I get to 2 days and 7 hours, and they're like, I'm sorry, Mr. Herbert, you got to pack up your stuff.
Yeah. I think Judge Hall was extremely patient. I think she wanted to give everyone an opportunity to be heard. The plaintiffs had an expert witness in interior design of a certain pedigree. I think that presentation of evidence from that witness made the trial longer. Certainly, I needed a good opportunity to cross her. I know that I spent a good amount of time on that. I think it was time well spent because we knew that although at its core this was a case that was really about less than $100,000 of money, the accusations and the allegations of fraud and reports of wrongdoing, and you saw, the damages they asked for are well over $9 million, almost $9.5 million. So as I was sitting at counsel table, hearing some of these numbers for the first time during closing, I just thought, I really, really hope no one is buying into this, because I have always seen this case as not so much about the money, but even if it were about the money, it was about a small amount of money that could never justify the kind of attorney's fees that we understand were charged.
I don't want to jump ahead. My question is going to be, in a case like this, how did you approach closing? But before I maybe get to that, do you feel like maybe there was a turning point in those 12 days where you started to feel like maybe the plaintiffs had gone too far out on a limb, or maybe the jury was really kind of understanding what was going on? And then my ultimate question is, in my mind, I know how I would handle that closing, and I'm curious what you chose to do.
Okay. So, having tried cases, Sometimes you can get cues from the jury box and they're spot on, and sometimes you think you're getting cues
Sure.
from the jury box and they're not on at all. But I think progressively over the trial, for example, when I had no questions for the lawyer after his direct, and he just put out a really big number about how all these fees were reasonable and necessary because we did all these things to lengthen the discovery period, et cetera. There was a juror in the front who literally nodded his head, I think with me, when I said I had no questions. And I thought, oh, I think that was a good sign. Of course, that came towards the end of the trial. One of the things that I wanted to do in the case was make sure that from a consumer psychology standpoint, we didn't have jurors thinking, boy, this glass or that item, $500 for that does sound like kind of a lot. What is the true price? What is the value, et cetera? And so in Vordaer, we ask questions about, how many of you believe that for every product you buy, you should know exactly what it costs to manufacture, what it costs to transport, what it costs to store, insure, et cetera, et cetera. And I think by the end of it, they all said, I don't really care. If I like it, I'm going to buy it. If I need it, I'm going to buy it. Now, if there are promises made about, characteristics, et cetera, surely I want to make sure that they're accurate and the product lives up to it. So I feel like early on we were able to really plant the seed about how we don't price arts and accessories. You can't look at what something was purchased for per se years ago that became part of a curated collection and say, well, how can you mark that up? It's our price. And if you like it, great. And if you don't like it, you don't have to accept it. And so I feel like we made some headway with that. We had a juror who had experience hiring an interior designer. I thought that was helpful to us. During the trial, I think that there was some pretty heavy emphasis placed on mental anguish. For example,
The plaintiffs.
the plaintiffs,
Yeah.
yes. For example, one of the, and it's not the typical, I feel like certainly there are objective manifestations of like a substantial disruption of someone's daily life and routine, right? We know Parkway versus Woodruff and the elements of what you really need to show to have a good compensable mental anguish claim. And certainly circumstances can lead to that. Here, it was distress over not knowing where a pillow came from. It was distress that a certain color or shade of window covering may not have been the one that actually was placed. Why that happened actually turned out to be a problem with an order fulfillment and a miscommunication between a project software and reconciliation that was only in draft form. But the idea was, I can't live with this stuff. Every time I look at it, I get so upset, et cetera. And frankly, that's not enough, right? As a matter of law, that's not enough. Nonetheless, it was used during the case and not non-suited or dismissed until the very end. So when it was used, we had to probe at times and ask questions about that sort of thing. And in closing, after hearing all the numbers and sort of doing a gut check, like, okay, I still think that this is way outside of what is fair, what would be fair and reasonable. We really harped on the expert witness who had done a project recap. When she did her math, she came out with a number that was about $9,000 off from my client's number. Okay.
That's about what they awarded.
And the jury awarded a little bit more than that on the DTPA side, but on the breach of contract, there was no finding. Significantly, the plaintiffs didn't pay their last bill, $5,000. And so we went back and forth with the expert and whittled down that $9,000 difference to 30 cents.
Wow.
Because I said, once you take into account the $5,000 that wasn't paid, where are we left with? She said 30 cents. I said, am I plus or minus? And she said, well, your folks would owe 30 cents. But I'm not saying that's what happened here. So we were able to use that aid during closing to say, this is about 30 cents. Closing, because you asked, I brought a clue board, the board game Clue, into the courtroom. We talked a little bit about the assumption that there was a contract signed, and my client's belief that there was a contract signed, and the plaintiff's trial of the case that there was no contract signed. So as I thought about, how can I make this a little more interesting, we did have a study, and that is the room where the contract had been presented. We did have some characters. We had the Colonel Mustard and Miss Peacock, and I literally took these pieces out and sat them on the table in front of the jury. And I said, okay, let's walk through this. You're standing in the study, Mr. Plaintiff. Yes. And where's your wife? Well, she's over here. Okay. And then what happens? Well, the paper comes out. Okay. So the paper is out there in the study. And then I did that during part of the cross. And then I came back to it. And in closing, I took the board out and I said, this is where the contract was formed. It happened in the study. It happened on this day. Plaintiff one, Mr., was standing right there. He didn't sign it, but he acknowledged it, and then he lived up to it every step of the way for the next, 6-8 months, whatever it was. So that was kind of cool to have a prop. There was an objection to using the clue board.
Real quick time out. Were there any emails exchanged or text between them where someone said, pursuant to the contract, maybe something like, hey, the contract says X, where they were acknowledging that there was a contract aside from the performance?
So there was language on an invoice that my client sent that said design fee per contract. And then on the flip side, once the questions were being asked by the plaintiffs at the very, very tail end of the project, there was a self-serving email about, I have a cost plus project and my oral agreement, this or that.
Okay.
And so we thought that seemed a little bit, too intentional. But this was not one of those cases where the texts and emails are flying back and forth and they're just, you can mine them and they're so rich. It wasn't like that.
Okay. Sorry. So you were saying they objected to your clue board.
Yeah, they objected to using the clue board, and the court, to her credit, asked for the legal basis and got none and said, okay, that's overruled. Let's carry on.
He's too creative, Judge.
Yeah. Other things that happened, during the case, I feel like we.
Well, let me ask specifically. So how did you? So I've had cases like this. It walks in, you look at it, you go, look, I'm going to file a response. I'm going to call these people. I'm going to see what this fight is really about. I'm going to call a good mediator. We're going to offer to pay 10% of this fight. We're going to get out of this. And then you go to trial and they're like, I want 5 times the value of my house. So how did you tackle with the jury, how nutso that sounds?
Yeah, well,
because defense lawyers do that to me all the time.
Absolutely. We did. And they did not make, obviously I'm not going to get into whatever demands were made at mediation, and offers, but I feel like, the case should have never gotten to trial. When we did get to trial, yes, you're darn right. I basically said, this is crazy. This is absolutely nuts. We had jurors who had given up. Let me back up. Judge Hall was so good with these jurors, allowed them to basically create the schedule. And so as an accommodation to them, they're giving up their time. She asked them, look, do you guys want to start early any days and stay late? They wanted to start early almost every day and stay late almost every day. And so we had real life people, speech pathologists. with patients who had repeated treatments that were now being missed week after week, because of this trial. We had disruption in work schedules, family lives, vacations, things we learned from the jurors indirectly at the time, and then directly once the trial was over. And so I feel like feel like I could sell the notion that it was so outrageous and a tremendously disproportionate burden on everybody for their desire to stick it to my client, and really not have a legitimate basis for it. To your point, how do you get to those numbers? How do you connect the dots between the alleged harm and the amount of money they were asking for when the whole project was only $374,000 and they didn't return a single item?
Yeah.
And so they had the value of the design services, the creative talent, all of the labor that went into that. And then they had the items, furniture, art, accessories, all those things that were placed there. And on top of that, they wanted more money.
They wanted mental anguish for the furniture that they didn't want to take out of their house.
Yeah, because they had been frauded, right? That was their idea. Is they saw it and they liked it, but they were at the same time they were tarnished with the mindset that they paid too much for it, or they didn't get proper backup to support if they paid right amount or not. So that was their anguish, right?
I think that was certainly part of it, and then not being able to have traceability for each item to the penny that they were charged and that they paid. Except for, of course, the last $5,000, which they never paid.
So for my entire life, my mom owned and operated a design and upholstery shop down in Clear Lake. So I'm going to ask a question that's going to sound misogynistic, but I feel like I'm qualified after summer of delivering furniture and drapes and fabrics. So here's my question.
Kyle doesn't speak for the Dirty Verdict podcast or Peter Taaffe or Bill Ogden.
Was this emotional fight about the pillows giving people mental anguish, was that coming from the husband or the wife or both?
Well, I think it was really coming from the wife, but I believe, to his credit, remember, this is a newlywed couple, relatively speaking, married a couple of years, I think, at that time. I think he wanted the home to be perfect for her. And wanted to do whatever he could to get to that point. And I think when she was upset, he was upset. I don't believe he, although they generally pled for mental anguish at the trial, he did not,
he wasn't buying into it as much as she was.
He wasn't trying to lay,
he had gotten over his pillow anxiety.
Yeah, I would say that.
So the mediation, how early was it in the process?
Mediation was not early. We actually had already done our depositions, but it was before the breach of contract claim was alleged.
Yeah, because that's the problem on these cases. If you don't settle it early,
everybody's in.
Then the attorney's fees have already gotten to a point that they have no choice but to give it their best shot and throw what ultimately was good money after bad, but that's usually how it goes. If you make
paid a design expert in excess of $50,000.
Did you get a sense of when you communicated with opposing counsel? Because I've had this go both ways. Did you get a sense of this really doesn't seem reasonable? There's got to be a way for everybody out of the rat trap. Was it his clients driving the bus? Or did he believe in this case, or did you get a sense one way or the other?
So it was the first case I had with this lawyer, and when you've got a lawyer that you're familiar with on the other end, you can have more candid conversations. So I don't know. All I can go on is what
Sure.
those lawyers said, and I got the sense that his clients were pushing hard, and I also got the sense that he wasn't talking them off the ledge.
Well, he's getting paid.
It doesn't matter.
Yeah.
Objectively, I really did try to appeal to my brother at the bar and saying, "This is crazy shit." Okay, I mean, stop it, right? And I didn't succeed in attempting to or getting a resolution. I would have loved for the case to settle. I did not want to spend, you know, the first 2 weeks of June and Memorial Day weekend and the week before that. I mean, I missed a lot of. I scheduled trips and canceled them because of this case. Tried to schedule around them. And we had 3 or 4 trial settings, and some of them were supposedly firm and going.
Yeah.
And they were a bust. And I didn't get to go on a trip with my family, to Colorado.
You were here arguing about pillows.
Yeah.
But I mean, it's easy to look in the past 2020. You won. You got a zero verdict. But remember, Kevin Spearman, up until that point in time, is being sued for $9 million and waiting for a jury of 12 people to decide whether he is on the hook through his business, whether his business is gone, and then whether he's got a significant personal liability. So with that in mind, I mean, I'm sure it was totally stressful for him, and why you made those sacrifices for him.
That's what we do, right? I mean, I wanted to be there for him and to feel for him because, again, we did not get those numbers until closing. Okay, the amount of money that the economic harm was a very small number, relatively speaking. Not a number that's commensurate with spending 12 days of jury time and district court time, but we were the defendant. We didn't have a choice in that matter. So my heart really went out to him and his team. His right hand at the company is someone named Cindy. And Cindy was there for the whole trial, sat at counsel table, was good for him, I think, a calming presence. There's a lot of moments of prayer and hugs and embraces and obviously relief at the end. Because you don't know exactly what that jury is thinking.
You never know what they're going to do.
What did you talk to him afterwards? The juries?
My team did. I was not there. I watched the verdict being announced by Zoom. I was away at the time, but I did speak with a couple of jurors after the fact by phone, and they shared their insights. And the person who turned out to be the presiding, had some very sharp comments about the case and the kind of case it was, and really feeling a sense of duty to see this through, and was very proud of this verdict. In fact, I think the jury called themselves the KSD 12, Kevin Spearman Design 12. I think they bonded with the court. I believe they made Judge Hall a T-shirt with something like the KSD 12 or something on them. So, I mean, from the perspective that it seems like this was a horrible, horrible waste, there really were some good things that came of it. I think that group of 12 bonded and got to know each other. I always believe every trial is a mini study in human psychology, right? So we get to explore ourselves and how do we think about consumers and think about homeowners, and from the business standpoint, what's my client thinking and all that. I got to try this case in part with my son, which was a real treat. My son, Matthew, had graduated from SMU Law. He was watching the trial like Mike Strike by Zoom. And my co-counsel had left for her trip. We were on like day 6. Okay, this trial was supposed to be 3 days. And so she didn't want to go, but it was her family. And I said, go. This is still the $60,000, $70,000 case that I evaluated it to be before. Go. And she said, okay, reluctantly. So my son is watching on the Zoom, and he said, where's Kelsey? It was my co-counsel, who did a great job on the trial. And my wife, who was watching as well, texted and said, Kelsey had to go on a trip. And so he said, can I come? And my wife said, you're studying for the bar exam. And he said, no, I need to come. So I'm not studying anyway. I'm watching the trial. So he showed up the next day and spent a week with me coming to counsel table, and got to live the life of, what it's like to be in trial. And it was.
And he immediately decided not to take car, and he's now studying dental. Going to be
He's in Bali surfing. Yeah.
Oh no, not quite. I think it just reinforced for him what he wanted. I mean, I think that trial bug has been bitten. He really is into it, and he learned a lot during the experience, and had a lot of questions. But he would draft memos for me at night. He understood that trial being over for the day doesn't mean your day of work is over. You go back to work.
It's like part one of your day is over.
Yeah.
Part two has just begun.
And then when the jury says we want to start early at 7:30, guess what that means? You're up even earlier and driving from the Woodlands into Houston to be there in time.
Wow.
We had, very, very long nights, long days, short.
What an interesting
naps.
case. So you brought a book. I want to make sure we hit it just as we wrap up. And Peter might have a couple of follow-ups.
Yeah, so this is a book written by, and say the name, but the plaintiff, and as we are to do, as we do when we're in trial, we want to know everything about our opponent or opposing lawyer. And you found a book, and you made, I guess you were able to use some of the language from the book with the cross-exam?
Yeah, I mean, unlike TV, right, where these things usually happen, in real life, it doesn't happen that way. But the plaintiff, homeowner, was a book author who happened to major in English in college. And we heard about his having authored a book at his deposition. He liked to talk about a lot of things that weren't necessarily responsive to the question, and I was okay letting that happen. In any event, he wrote a book, and so I got the book. And as I said to you off record, offline, anytime we've got a witness, expert, or fact who has written anything, we want to get our hands on that published work and see, is there anything there that we might be able to use? So I read this book. It wasn't too long. I don't know, 300 or 400 pages. And there's a line in it that involves a trial. And in the trial, the characters are talking about preparing the witness to testify. And this line said, just answer his questions, dear brother, and we'll be out of here quick. So there was a period of time during my cross-examination of the plaintiff where he was not answering questions. I feel like the jury felt the same way. They were looking away. And so I happened to have the book. I took it out and I asked him, do you recognize these words? Just answer his questions, dear brother, and we'll be out of here quick. And so the plaintiff smiled at me and said, you're taking that out of context. And I said, no, I'm just asking you, do you recognize the words? And he said, I do. And I said, will you bear that in mind and answer my questions so that we can all get out of here, more quickly? And he said something like, I'll try. But, the chances of a line from a novel, having the opportunity to use that in a trial, taking that witness's own words, and that moment just kind of
essentially a fact witness.
Yeah, organic.
That never happens.
Yeah, I mean, it just happened, and so I just felt like it was an interesting moment. I can be a little cheeky, and I enjoyed that moment at trial. I think again, over the course of 12 days of a lot of extraneous information for everybody, others found humor in it, and I don't think it backfired.
Yeah. Well, I'll say this, when I was doing hourly work, clients would say, you'd go through the analysis and like, okay, you're going to spend $200,000 to recover 50. And the clients would say, I don't care. It's on principle.
Yeah.
And I'd say, look, I'll tell you what's a lot better than $200,000 paid to a lawyer, like a Lamborghini. Like trust me, you're going to enjoy that Lamborghini a lot more. A trip to Italy with your whole family. Do that and pay the 50 grand and the other 150 go to Italy. So this case to me is a pretty good example of why that's something to think about for anyone out there wanting to spend a lot of money.
Harry case. I really appreciate you sharing it with us. It's really interesting.
Well, you guys have a lot of guests on here who have had large cases, large verdicts, and I enjoy the podcast. But I'm appreciative that you wanted to hear about this small case because it really is an important case, and it involved real people, real emotion. Again, in our case, we had a very large firm, 600 lawyers, 6 different lawyers worked on this case. I'm going to say our small firm and a person, a defendant, a client, Kevin, who had not been, in trial before. And next thing you know, he's got people gunning for him, for about $9.5 million. Thank you for recognizing how important it is to have trial, have good advocacy, and bring that experience out.
Yeah, you got it. Well, Matt, thanks for joining us. Thanks for sharing that story. And thanks to everyone else for joining us. If you like this, subscribe and follow us on Instagram, Spotify, YouTube, Apple Podcasts, TikTok, and anywhere you get your podcasts. And we'll call it a good night.
And